All right, I guess we'll go ahead and call the meeting to order tonight. This is the May 19th, 2015 meeting of the City of Everett Planning Commission. And we'll start out with our roll call.
Chair Stewart.
Here.
Commissioner Holland.
Here.
Commissioner Tisdall.
Here.
Commissioner Jordison.
Here.
Commissioner Beck.
Here.
Commissioner Zielinski.
Here.
Thank you. And next is approval of our minutes from May 5th. Have the commissioners had a chance to review them? And does anybody have any corrections, changes you'd like made? If not, would someone care to make a motion to approve the minutes?
I'll move the minutes.
Second.
Okay.
Commissioner Zielinski.
Aye.
Commissioner Beck.
Yes.
Commissioner Jordison. Yes. Commissioner Tisdall.
Yes.
Commissioner Holland.
Yes.
Chair Stewart.
Yes. Thank you. All right, next on our agenda would be reports from commission members. So we'll start down at the end with Commissioner Zielinski.
No report from me tonight.
No report from me as well.
No report.
How about our trip to?
I actually showed up late to that meeting, so I missed a good portion of it, but I think you should kind of.
Okay. So we went, the group that's working on the TOD down by the transit station went down to Methuen in Seattle and spent some time talking about getting some conceptual drawings and what kinds of things go in and what kinds of uses, and that was very, very, very good to see. It's going to be a great project if it can move forward.
Is this a master plan that Methuen's working on, or?
Concept, I think I would call it.
So what Methuen is doing, and actually Greg met with Ed Peterson and Craig Scottle, and basically they're identifying opportunities to do some renderings to kind of get the master planning process, getting people excited, telling what the possibilities are. So the hope is that a master planning process will actually evolve out of this. So.
As I recall, maybe it was a couple of years ago, there was a workshop held at the Everett station, and there were maybe some, I can't quite remember if it was Forterra who
Yes.
did some work, so that might be of use.
This is an update of.
Okay. All right, thank you. Commissioner Holland, any report?
No report from me, thank you.
Okay, and I can't think of anything to report either, so. So then moving to staff, do you have any comments?
Yes, just briefly, Alan Giffen, Planning Director. We will have a meeting on June 2nd, at least one agenda item, a couple of code amendments that the Commission agreed to initiate a meeting or two ago, one concerning the definition of family in our zoning code, and one related to the findings that are required to be made on subdivisions. We may have other items, but at this point, those are the only certain items on the agenda. That's it.
And do you anticipate a second meeting then in the month of June, or maybe just the one?
I would expect we'll have a second meeting on probably on the transportation element. We had a briefing previously, but that was without the policy document. That was really more of the existing conditions, and so I'm hoping that we'll have all the information from our consultants to talk about the transportation policies and project lists for projects that would be necessary to accommodate our growth over the next 20 years.
Okay, thank you. We'll look forward to those meetings. And then, so any other staff comments? Okay. So we do have time on the agenda right now for any comments from those citizens who are attending, and these would be comments not on our agenda item tonight. So if you have something else that you would like to talk about. Okay, seeing none, then I guess we can move right into our item number one. So tonight we're holding a public hearing, and the Planning Commission is going to be working on putting together a recommendation for the City Council, and this would be on amendments to our interim land use regulations for recreational marijuana under State Initiative 502. Because this is a public hearing and we will be making a recommendation, I guess first order of business would be if any of the commissioners have something that you would like to disclose regarding this particular topic. Seeing none. We do have some materials that were distributed tonight, and we did receive a staff recommendation, a memorandum, including staff recommendations dated May 12th. And there was also a suggestion from staff in there on how we could proceed to address the 10 different amendments that we've been discussing previously, and there could be some other things that come up tonight. Would staff want to talk about that procedure?
Yes, I would like to address the Commission briefly. I do have a PowerPoint, and we'll talk a little bit about procedure, but as Chairperson Stewart mentioned, this is has been advertised as a decision public hearing in which the Planning Commission would be making recommendations to the City Council for amendments to our interim regulations to make them non-interim. That is what the City Council had requested when they last extended the current interim regulations. And we have had 3 previous workshops, one in February, one in March, and one in April, at which we discussed a variety of different potential code amendments. And you have had quite a bit of discussion and also received a lot of public comment throughout this process, and we've expanded the list of potential code amendments as a result of public testimony. You have received in your packet some comments that we received prior to our mailing it out last week. There was a lengthy bit of information provided by Brian Bodge. There were also a couple of other letters and emails concerning allowing retail in the Everett Station area zoning. You've received since then at your places tonight a lot of comments centered mostly around overwhelmingly the comments were supporting adding churches to the list of sensitive land uses from which a 1,000-foot buffer would be required should that be made one of the sensitive land uses under our regulations. There was also a memo in there for a letter from Philip Dottie, who's here tonight and will comment on production and processing facilities. Just before I walked across the street, got an email from Rick Lipinski also recommending taking allowing Tier 2 and 3 production facilities in our industrial zones. So that's kind of a summary of the comments that we've received in writing from people. And for our hearing tonight, what I would recommend, and I know that we've got people that have signed up that when we're asking them what item on the agenda, I didn't realize that we'd set ourselves up with a sub-agenda of item number 1 on the agenda, and so what I will recommend to the Commission is that we would take public testimony on each line item, and when you're done with the public is done making comments on that line item, close the comment period for the comments for that item so that you can then discuss and vote each individual potential code amendment individually. I think after our discussion at last month's meeting, it became apparent that it would be more of a challenge to try and approve these as a group or in a package. And so I'm recommending that we have discussion on each individual item. And at the end of the meeting, when you take action on the resolution, we will attach to that an exhibit that would list all of the recommendations that you're making to the City Council. So with that, unless there are other questions or comments about how to conduct the hearing tonight, I would just jump into the points as they're stated in the staff memorandum. This is in the same order as we set it up in the staff memo, which is a little bit different than the order that we listed them in the notice about the public hearing. So you'll note in your comments tonight, we had a lot of people commenting about item 2 and item 7 on the list, and that's based upon the hearing notice that we sent out. It's different than the order that they are in both the memo and how I propose to walk through them tonight. But because you have a lot of testimony or a lot of comments in your written materials about item 2 and item 7, item 2 on the notice, which I believe is what people are referring to, is a possible limit on the number of Tier 2 and 3 production and processing facilities. And item 7 was adding churches, synagogues, temples, and mosques to the list of sensitive land uses that would require the 1,000-foot separation. A little bit different order in the packet and the PowerPoint that I'm presenting here, but didn't want there to be confusion about individual item numbers. So any questions about that before we get started? Okay. So the first item that we're making a recommendation on would be whether or not to allow Tier 2 and 3 production and processing facilities in industrial zones. Currently, the interim regulations allow only the smaller Tier 1 production and processing facilities. Staff's recommendation is not to expand that or open it up to Tier 2 or 3 facilities. And this is based on still trying to take a conservative approach with regard to production and processing. We do not have any production and processing facilities in the city, even the smaller Tier 1 that are permitted under the interim regulations. The thought there is to still take a conservative approach until we have at least a Tier 1 or several Tier 1s in the city to understand a little bit better what the outward impacts of a production and processing facility of that scale might be before opening it up at some point down the road, or considering opening it up at some point down the road to Tier 2 or 3 facilities. So the recommendation is not to allow Tier 2 or 3 facilities. So at this point, I would recommend that, unless you have questions for me, to open up the hearing or the meeting for public comments on this individual item.
Okay, thank you very much. So I don't know who wants to speak on which of the amendments. So I realize some of you will want to speak on this one and perhaps others, so that's fine. So Philip Dowdy. And if you wouldn't mind saying your name and your address for the record.
Yeah, absolutely. I'm Philip Dowdy. I live at 1608 East Republican, number 303 in Seattle. First things first, I want to thank you guys for your hard work. You've been at this for, it probably feels like forever to you at this point. And I've done a lot of work on the other side of this, and I know how the hours just wear you out on this. I'm here representing Mojo Rising, which is a Tier 3 applicant who wants to locate in Everett. They've got an application in a different jurisdiction, but they've run into an ideal warehouse that's pretty uniquely suited. You know, I guess relevant to just the broad discussion of whether this makes sense in industrial areas is our experience as an industry so far in Seattle and Tacoma, which I think would be the most relevant jurisdictions to inform you guys, has been pretty positive so far. There have not been problems with neighbors, you know, odors, that sort of thing. And believe me, the media would be reporting it if there were. I live in Seattle. I would know about these problems. I would get called about them, like I'm supposed to go fix them. Ultimately, I think it is a compatible use in industrial areas. And in my guy's situation, they've got a landlord who wants to rent to them. It's a legal use under state law. And, you know, at some point, we've got to respect a landlord's right to do what he wants with his property that's legal, and that is. So I would encourage you to allow for production and processing in the broader industrial areas, and I'll come back and address 2 and 3.
Okay, thank you. Next, Arnold Brasseur, would you like to speak about?
Comment on 2, please.
Okay, and I'll make a note. Next is Bob McCowan.
My name is Bob McGowan, and I live at 120 Long Street in Snohomish, Washington. And I'd like to comment, first off, thanks for doing what you're doing. It's a tough job, and I appreciate what you're doing. I don't think it's a good idea to locate. I'm a business owner. I have an 8,000 square foot facility in the Frylands Industrial Park in Monroe. I'm subject to Puget Sound clean air quality scruples, and I'm heavily permitted with the city, the state, and the county as well. In talking to my landlord, he's got about 600,000 square feet between Monroe and Mukilteo. And his concern, and his he's not going to rent to a pot grower, is because it attracts a bad group of individuals. Light attracts light, darkness attracts darkness. It's a noble idea that Allison Holcomb had when she brokered I-502, but it's not working. And so I'd like to encourage you to hold back, because as you read the Herald, there's quite a bit of growth starting to occur in Everett. The pallor and the atmosphere of Everett is changing. The ACLU tried to shut you guys down, or did file a kind of a scary letter saying, hey, don't do panhandling, don't restrict people from panhandling. And I think the picture that I'm trying to point here is that there is some inertia, there is some momentum of growth, and there's a changing of the atmosphere in Everett. And I'm really concerned that if you afford footholds to pot growers, you're sending the wrong message, certainly to our children, and you're going to forbid other businesses from wanting to locate because they don't want to locate next to a pot shop. Thanks a lot.
Thank you. Next is Sonia Bodge. Would you like to speak about this item? Okay. Next is Dennis Kavanaugh.
I'm going to wait and listen.
Okay. And the last person who signed up is Brian Bodge.
I'll go ahead and just
Okay.
say a few words. I am in support, and by the way, thank you guys again for letting me speak here again today. I do support Tier 2 and Tier 3 facilities in Everett. One will, in that it will support retailers in the area, and it would be similar to allowing outlawing a brewery when you have restaurants around. So this is something that's integral to the business and the industry. I think that the testimony that people have brought here before has shown that these businesses are going to be compatible with the usage in the city, and I think that's about all I've got.
Okay, thank you. And those are the only people who have signed up to speak on, at least we'll take one amendment at a time on amendment number 1. If anybody else would like to speak, now is your opportunity. Okay, seeing none, do I hear a motion to close the public hearing on proposed amendment number 1?
So moved.
Second that.
Commissioner Zielinski,
Yes.
Commissioner Beck,
Yes.
Commissioner Jordison,
Yes.
Commissioner Tisdall,
Yes.
Commissioner Holland,
Yes.
Chair Stewart.
Yes. Okay. So turning to my fellow commissioners, any questions, discussion on this item?
This is one I really struggled with. There's a lot of indicators out there in terms of economic development that this is a booming industry. And one of the things that I really struggled with is I looked at what the trends are in terms of on a national level. There's a number of states that are probably going to be legalizing recreational marijuana in the next year or two. So this is a growing trend. And as a result, there is an industry that is responding, and it's becoming more and more mainstream. So, I understand the concerns, the conservative approach, But I also think there's the benefits in terms of economic development as well. It's very, very hard for me to go against a staff recommendation, particularly one that's been so carefully thought through. But what I've been struggling with is there seems to be a particular type of land use process that we could potentially use and recommend that might be more prudent and still allow for a conservative approach. And that's the special property use, land use application process. And I was actually going to ask you the question, but it seemed like a more appropriate time to ask it now. Was this considered?
Yes, in fact, I think some of our earlier discussions, perhaps one of the workshops before you were appointed to the commission, Commissioner Beck, we talked about not exactly the SPU, Special Property Use Permit process, but one of the items that we have discussed was allowing for the, not only Tier 2 and 3, but also allowing for a reduction in the current interim regulation of 1,000 feet from residential zones for production and processing, and if it was to be proposed within a distance of 200 feet of a residential zone, that there would be a public notice process, not the hearing examiner hearing process, but more of a well, it's a planning director review process where there's a public notice, opportunity for comment, and opportunity for appeal should anybody be dissatisfied with the decision that came from that process, rather than something that was just permitted by right, where you wouldn't have that public involvement or the opportunities for appeal. That is something that's been discussed, but based on feedback from our economic development director and our mayor, the preference and the recommendation of staff is to take this conservative approach, as I've mentioned, on most all of these items, and just see how the experience either here in Everett with Tier 1s or in other jurisdictions with the Tier 2 and 3 yield any more information that give us the opportunity to consider amendments in the future if they're found to be minimal impacts from the Tier 2s and 3s.
Thank you. One thing that I do want to kind of add, because I did do a fair amount of research on this, is in terms of economic development, this is an article that came from Inc. magazine, and this is pretty mainstream business magazine. And the headline kind of says it: proof is in the pot, legal weed gives Colorado business boost. And the jobs that they're talking about in this particular article have nothing to do with the actual industry itself. It's kind of externalities. It's steel workers, it's electricians, it's software application folks, and real estate folks. So the trends are, in terms of the industry, is that it's actually helping Colorado. They've kind of paved some land a little bit ahead of us. The other thing that I struggle with is there's some real medical benefits to marijuana, and that's part of what these production and distribution facilities would be also doing and serving. So I really do understand the concerns, the conservative approach, the history of marijuana, the perception, the public perception. But this seems to be a very evolving issue. And I think the trends are pretty clear at this point. Thank you. Alan, thank you so much for all your hard work on this as well.
Thank you.
Any other commissioners have comments?
Well, I'm much less hesitant than Commissioner Beck to disagree with the recommendation from the planning staff, but I appreciate your position and trying to accommodate all the various parties. I feel that it's, and I understand, I think the whole idea of we should save our industrial properties for more suitable uses. I understand that, but I don't think it's the real, in my mind. I wouldn't call it an outright fabrication, but it's more like a red herring. It's kind of giving us a reason to say, oh, we don't want to do this. This is a bad idea. And to me, it's more an issue of freedom and democracy as opposed to whether or not it's in the best, economic interest of Everett, or whether it's people are fearful of it. I feel that part of the reason we're here having this discussion is because bureaucracy ran amok back in the 1930s, and there's a man named Harry Anslinger who started all this. And I don't even like to use the term marijuana because cannabis is the scientific term, and marijuana is a slang term that was mainly introduced by Mr. Anslinger, and it was he was a public official who was insecure about his career, and so I feel that we're kind of just continuing this legacy of his. And many tens of billions of dollars have been spent on enforcement and on prisons, and that, to me, is really the crux of this, is like, okay, are we going to just continue to do business as usual, or are we going to question the wisdom of, was this ever a good idea in the first place to, prohibit this natural substance? So I don't really have any problem. I don't like going against the mayor, but I don't have any problem going against the recommendation of the planning staff, because in my mind it's really just a matter of having the courage to just do what's right. There was an election, and the freedoms that we embrace freedom and democracy, but we can't just pick and choose whenever it suits us. We have to really support freedom and democracy, and I think that's what's at stake here.
Thank you. Other comments?
Ellen, were you able to, I know we had a few meetings, we had asked for the jobs and the salaries, and were you able to look at that, and how does that compare with other businesses that might be using that same type of industrial use, or that footprint of ground? Because I think Lainey did, and I've had a couple of discussions with her since, that do have to agree that we got to make sure that we're using the highest and best, and we're diversifying what we're using up that industrial land for. But one of the bones was that, that there wasn't, that this wasn't the best use based off of salaries. And when I look at this, based off of a couple of businesses that I've been involved with, these are some pretty good numbers.
Okay, thank you for the question, Alan Giffen, planning staff. In your packet, first of all, we did put some information that came from the Economic Alliance of Snohomish County concerning workforce and hourly wage data, and this information is based upon King and Snohomish County, and there are a number of different job classifications that are typical in a lot of our industrial zones. In addition to that, second item in that same, in the next page, was also from the Economic Alliance that talked about some engineering type jobs that are often associated with industrial zones and industrial businesses. That information was, I haven't attempted to verify that, if there's anything either inaccurate or to find additional job classifications that may not be covered here. We did get also on your at your place tonight a letter from Adam Smith, CDEO of Avitus Agriculture, who provided some additional information about some wage or salary levels for the marijuana, recreational marijuana industry, some estimates that, you know, I, again, did not try to verify or to find anything to the contrary. This is a fairly new industry, and there's not, in my research, previously any reliable source of data. So this information, you know, I'm sure it's probably as accurate as any other information that we've been able to turn up concerning wage rates. I don't know if that answered your question, but
Yes, it does.
okay.
And then the other question I had is in more of Adam's conversation where it was odor, and on the second page, or I guess it's on the back page that you have, the different growing techniques and the odor controls. And I know from serving on Puget Sound's advisory board, the rules and things that have been written thus far, the odors have been able to be taken care of. And I think when we went on a tour, the three of us went on a tour, any more conversation about odors at the growing level?
Not that I had nothing new, no information, new information. I too also viewed the Tier 1 operation out in Snohomish County in the rural area, and my observation was, I think, the same as yours, that there was really no outward noticeable odor outside the building or even inside the building until you stepped into the sealed growing room that this particular operator had constructed very carefully, and that even within the different growing rooms, there were different levels of odor based upon the stage of growth of those plants. In one room, it was, on my visit, it was a harvested area, and that really is the one that had the most odor in my observation. The thought about odor impacts and that being regulated by the Clean Air Agency, you know, we defer to the Clean Air Agency. When it comes to odor issues, they have the expertise that we as a city do not. But again, the recommendation of the mayor and our economic development director, not only with regard to the industrial land supply, but also with regard to just external impacts, since we haven't had any Tier 2 or 3 or even Tier 1s in the city to compare with, was to take a conservative approach. And if we down the road see that there have not been the impacts that people are concerned about, that it would be, you know, another opportunity for amending these in the future.
And my final is, can we get specific into tracks or blocks, or I mean, I could see some of the conversation that's been had around maybe locating this out by the aerospace park, or, you know, the whole Seaway Center, but like down where they load the rail cars with Allied, you know, has that exchange program down there on. Could we limit these to a geographical area, or it's by zone, so then it would follow wherever that zone would be?
That's one way of regulating it differently, perhaps. If, for example, if you wanted to allow it in one type of industrial zone, but not all of the industrial zones, you could specify a particular zone. You could even get more fine-grained and say that it, for example, if it were to be allowed in industrial zones, but you didn't want to allow for something within, say, the area of shoreline jurisdiction because you wanted to preserve opportunities for water-dependent uses, and none of these businesses, as I can understand them, would be water-dependent. That might be even a finer grain way to split that. Or you could even confine it to a specific geographic part of the city if you had multiple zones that you wanted to allow it in, but only in a certain portion of the city. So we can get as creative or as nuanced as the commission would like.
Thank you.
Other comments? Well, is somebody ready to make a motion regarding this amendment? Or you've got a comment?
Yes, please. So I too toured the Tier 1 facility out there by Lake Bosworth and noticed that it was just a family-run operation. I believe he said his son does most of the work there. So you have in a 2,000 square foot area, I think the garage was, and about 1,500 square feet was actually grow facility, where you essentially had one person running the entire operation, another person essentially taking care of paperwork, things like that. So for a 2,000 square foot building, you really have two people that are running it for a period of 5 weeks when they do their processing, and then they bring in some folks for a day or a two to help them process that. So if you turn that into a 20,000 square foot facility, you kind of do the numbers. You don't have a really good footprint, in my opinion, for living wage jobs on a permanent basis. These are not jobs where people are getting benefits or that nature. They're not, so I just have some real concerns about eating up our industrial lands with temporary employees that may be making a decent wage, but not really a living wage. So that's my opinion on the Tier 2 and Tier 3 facilities at this point, until we have additional information that would show otherwise. So.
Other comments, or is somebody ready to make a motion?
Actually, I have a question for Mr. Giffen. The zones that are being considered for these Tier 2 and 3s, do they permit the distillation of consumable alcohol as a permitted use right now?
Yes.
Thank you.
Ask what that meant. Ask that question. Can you help me understand it?
I was just wondering if the zones that are being considered for Tiers 2 and 3 under this amendment have as a permitted use already the distillation of consumable alcohol, so liquor as a business, yeah.
And for the public, the answer to that question is yes, those zones do allow for breweries, distilleries, wineries, and bottling plants.
Well, I'd like to make a motion then.
Okay.
I'd move that we.
One comment?
Okay.
Sorry.
Go ahead.
Just kind of along those lines. So these industrial lands, I think it's important to note, these are the only lands that are appropriate for market scale production in terms of infrastructure. So if you are going to do production and distribution, and it doesn't even matter if we're talking about cannabis or if we're talking about a nursery, these are the appropriate locations based on the purpose and design of these districts. So I think that that's a really important consideration. If you are going to have these activities within the city of Everett, these are the lands, these are the locations where it's possible.
Other discussion? Yes.
I just have one more comment. I heard it referred to as an agricultural use, which I don't know if any of you folks have ever lived on a farm, but I have. And an acre has 43,560 square feet, and
560.
And 30,000 square feet isn't even 3/4 of an acre. And you can't do any farming with 3/4 of an acre. You can't really do much farming with 20 acres. If you ask any Skagit Valley potato farmer, he needs a quarter section. That's 160 acres. So there was some previous comments that this is like an agricultural use. I don't think it's any more an agricultural use than maybe the garden center at Fred Meyer's. You know, yeah, there's living plants there, and there's some sort of plant science going on, but it's not, you know, if we'll get into talking about the agricultural zones later, but it's kind of like the right size, you know, a 20 to 30,000 square foot warehouse. And that's really, I don't know, aren't we the only ones doing Tier 2 and 3, or are other jurisdictions looking at it in that way, or was that just something we came up with?
Tier 2 and 3s are a category that was created by the state. There are other jurisdictions within the state of Washington that allow Tier 2 and 3. Within Snohomish County, I believe that only Snohomish County allows for the Tier 2 and 3 within industrial zones.
Yeah, and another comment I have is that we have all these, car lots, and I don't want to just keep harping on, the double standard, but I mean, you take a nice sized car lot and you might have a handful of salesmen and a few people in the office, but you've got, acres of parked cars out there, and I don't know, I've never heard that. I guess you can make some money doing that, but, all I hear about is how little money they make, and, we've got car lots up and down Evergreen Way, so I don't know. That's just a comment that I have.
Are we ready to make a motion?
I'm ready to make a motion. I recommend we approve the staff's recommendation and not allow Tier 2 or 3 facilities in Everett.
And I will second that. Any discussion?
Question of Alan. The process, we find out in 6 months or 2 years or 5 years that ones or 2s and 3s are something that we like to put into our inventory of industries. What is the process that has to go through to get this decision changed?
Well, that would be a similar process to that which we've followed to amend the interim regulations to create non-interim regulations, and that's a code amendment process. That, under our zoning code, can be initiated only by the mayor, the city council, or the planning commission. So you as a commission have that ability. The public, a member of the public can ask the city to initiate consideration of a code amendment, and it's up to the planning commission is the process that we use to screen those and make recommendations as to whether or not to initiate that process. So they can be brought forward by the public, but only the commission, council, or mayor can initiate the process.
So it's a process that has to be initiated by the mayor and the council,
or the planning commission, and ultimately, of course, the city council would have to approve any changes.
Okay, thank you.
Can I put another recommendation on the floor? Or do we need to make them, you seconded, so we need to.
Make a friendly amendment to the motion, I believe.
And I believe the maker of the motion would have to agree with the friendly amendment.
I'm trying to think of how to do this, because what I would prefer to motion is that we permit Tier 2, Tier 3 through a special property use process, which means on a case-by-case basis, we consider the merits measured against various criteria, and you can condition as a way of dealing with Tier 2 and Tier 3 in our industrial lands. But I don't think that that's going to fit within the current motion.
No, unless there's additional comments, I'd like to have a vote on the motion that's on the floor.
Any additional comments, or should we move for a vote? Okay, we have a motion on the floor to support the staff recommendation to deny allowing Tier 2 and Tier 3 production processing facilities in industrial zones, and it's been seconded. So.
Commissioner Zielinski?
No.
Commissioner Beck?
No.
Commissioner Jordison?
No.
Commissioner Tisdall?
No.
Commissioner Holland?
Yes.
Commissioner Stewart?
So the vote has been taken 4-2, so that motion has failed. So now,
I'd like to make a motion to approve marijuana Tier 2 and 3 through special property use in our industrial lands, in the city of Everett's industrial lands.
Second.
discussion?
Yeah, Alan, if you could clarify for me on the special use permit, is that an administrative decision with just public notice, or is that something that have to go through the hearing examiner?
As I understand the motion, and I will look to Commissioner Beck to confirm this, that it would be through the hearing examiner process, whereby there would be public notice and a public hearing, and the ability to condition any application based upon identified impacts that might not otherwise be covered by existing city codes.
So Ellen is correct in my intent, but there is a second, Tier 3B, I think, where it would actually go to the examiner, and then the examiner would make a recommendation to City Council, and City Council would actually take the vote on the application.
And that's something that both our city council really don't want to be involved with, and our city attorney would recommend, yeah, and that's really with decisions such as a rezone where the hearing examiner would make a recommendation to the city council, and the city council has the legislative authority to approve a rezone. For a special property use permit, there's only one that I can think of that actually is a 3B that goes from the hearing examiner to the city council, and that is for aircraft landing facilities, because the commission years ago, when the code was rewritten, felt that aircraft landing facilities have a wider impact than the typical range of notification that we deal with on special property uses, and felt that it was more of a policy decision that the city council should be making.
Thank you.
Just another comment then for the commissioners. I see where the commission's line on allowing the tier 2s and 3s, and I guess it would be my opinion before we vote that in order to give the applicants, if we are to allow these, give the applicants some assurities that their permit's going to be approved per the codes that are in place, that I think it should be an administrative decision where we either adopt additional parameters, potential, which there are some in the, here, I think 2 and 3 or something, like some additional considerations for tier 2s and 3s, but to allow that uncertainty of a hearing examiner decision, and then the delay that they would have in order to get into operation, I think would be a detriment to any applicant, whether it's tier 1, 2, or 3. So that's just my opinion on that.
Because of the length of time and the uncertainty in the hearings examiner's process, did I hear you?
Yeah, correct. And they have the authority to add additional conditions, which could be things that when you enter into a lease or something like that, that comes in line.
Yes. Thank you.
Yeah, and that's a really good point. And it is within city code for other specific uses that there are evaluation criteria. So that could be something that's also part of the recommendation, is that we continue to work on evaluation criteria for tier 2 and 3, and what kind of conditions people need to meet in terms of the permitting process.
If I may, Alan Giffen, city staff, the existing special property use permit criteria, whether this was something that was reviewed through a hearing examiner process or a planning director review process that's more of an administrative, quicker decision process, all deal with external impacts such as odor, visual impacts, traffic, any kind of nuisance impact that could be generated as a result of a use. We would probably, depending upon the size of a building, if it was a new building being built, would also have an environmental review process prior to the land use decision being issued, so additional impacts could be evaluated at that time. And so I'm not sure, in trying to anticipate what additional criteria we might put into our current code to deal with tier 2 or tier 3 production and processing facilities. We already do have a criteria that deal with odor, and with the Clean Air Agency being the agency with the expertise, we would rely upon their authority. But I can't think of additional criteria off the top of my head or based on the work that we've done the last several months that would be necessary.
I'll add, because I have a copy of the general evaluation criteria, and you're correct, it covers pretty much everything. And one of them that could address the economic development concerns, consistency with the goals and policies of Everett's general plan for the area and land use designation in which the property is located. There's 11 of these criteria, and they pretty much cover the gamut, the spectrum of concerns that the community might have associated with this particular use.
Okay, other comments? Are we ready to vote then? I think we have a motion and a second. So I guess we'll call for the vote.
Commissioner Zelinski?
Yes.
Commissioner Beck?
Yes.
Commissioner Jordison? Yes. Commissioner Tisdall?
Yes.
Commissioner Holland?
No.
Commissioner Chair Stewart?
No. So the motion has passed 4-2. So now we move to the second proposed amendment. Steph, do you want to introduce
Sure.
that and see how
Yes. The second amendment would be a possible limit on the number of Tier 2 or 3 production and processing facilities. So the commission obviously just did recommend allowing Tier 2 and 3 facilities. Then our recommendation would be a limit of 1 Tier 2 and 1 Tier 3. Again, taking that conservative approach that if these are to be allowed, that we would monitor them to determine what kinds of impacts there might be over time, and at a later date, if it proves that these are not creating impacts, that we could consider taking a more liberal approach to the Tier 2 and 3 facilities.
Okay. So now we'll open up the floor for public comments on, this is Amendment 2. And I'll just go through the names, and feel free to approach the podium if you'd like to speak to Amendment Number 2. Philip Dowdy.
Do you want me to reintroduce myself for the record?
Yes, please.
Can I skip my address? I'm already in your record.
I'll ask the clerk. Okay.
Yeah.
Just your name is fine.
Thank you. It's Philip Dottie again, representing Mojo Rising, and I'm going to say thank you for your vote on the First Amendment and the Second Amendment. And on this one, you know, kind of my observation is, because I've been involved in this around the state, and every community has to sort this out for themselves differently. You know, Seattle doesn't care about putting, well, they did put some size limits on stuff. They actually did. They limited them to 20,000 square feet of canopy in certain zones that the port was concerned about. So everybody's kind of had to right size it for themselves. Obviously, what's going on here is a bit of an experiment for Everett. You know, my attitude in representing my clients is, as long as my clients can get through this, pick whatever limit you want. In reality, I'm a little concerned that because of the vote that happened in Snohomish County 2 weeks ago on banning it in the R5 zone, where you had about 85 people who were somehow in the application process for that zone, I think if you don't recommend a limit of some kind, you could have a land rush here, because you do have a lot of vacant warehouse space in Everett. So I'm generally not in favor of limits, but in this one, as long as it's a right-size limit and it works for the people who've been here, part of the process, trying to help you make this all work, then I'm fine with it. Thanks.
Okay, next, Arnold Bresser.
Thank you. My name's Arnold Brasseur, 1281st Street Southwest, Everett, 98203. Whatever limitations you're going to put, I ask you to make them the maximum limitations you can make. I'm not well versed on this, except that I believe the most limiting approach is the best for my city. Thank you.
Next, Bob McGowan.
Thank you. Yes, I'm in agreement. Bob McGowan, my address on record. Thank you very much. I think it's important that you restrict it and go as conservatively as possible. And I think that, like I said earlier, that we're in a position of growth. I don't think this is the kind of growth that we want, because it all goes up in smoke and it sort of destroys brain cells. And the experience that I've had is the people that I've hired off of Craigslist have aphasia. These are young men that are entry-level positions and they can't remember. So as a business owner, the sunk costs keep going deeper and deeper because they can't record the process that I'm showing them. So again, I think it would be wise and prudent to restrict that so that other industries that are more viable, that have more purpose, would have a place in the landscape of Everett's economy.
Next, Sonia Bodge.
Sonia Bodge, 3415 230th Street, Briar. I didn't really intend to comment on this, too, but people are talking about how it affects children and, you know, how horrible it would be. I have 2 daughters. My youngest is graduating from Mountain Lake Terrace High School this June, and I look at it as opening this up, making it more mainstream, makes it easier for parents to talk to kids about drugs. I've always been very open with my kids, and coming out of Mountain Lake Terrace High School, you know, we talked a lot about what other kids were doing, and I don't understand quite the need to make it look like such a pariah. Alcohol kills brain cells, lots of things do, and I think educating people, making it more out in the open is a good thing. Thank you.
Next, Dennis Kavanaugh.
My name is Dennis Kavanaugh. I live at 10818 Holly Drive in Everett, Washington. And after this, I'm just going to leave. I'm just going to tell you what I feel and what I think. I think allowing pot at all, I don't care if you want cannabis or marijuana or anything. You know, it was fun to smoke it in the 70s. It was a lot of fun. But I think it's the wrong way to go. I think you're going to have more police activity. I think it might cause maybe more accidents, just like drunk driving does. I think it's going to start costing our city a lot of issues. I think you'll bring in more crime, and I think in the long run things will go bad. So I'm definitely in favor, getting to this one thing right here, the more limitations, just like Bob said over here, the more that you can stop and say, let's look at this. If you're going to allow something, put as much limits as you can to take a good hard look, see what the other states are doing, the other counties, the other cities. I'm against this completely as it is. I just am. I mean, the day might come, I'm going to say one more thing. The day might come when they're going to say, okay, how about prostitution? Where are we going to let prostitution become legal and where's it going to go? I think we're going the wrong way. You look at drunk driving, people can drink, but yet more people die with drunk driving than anything else. I'm trying to say simply this, that the more that you allow that's bad, that we had laws against and now we're passing laws for, I think you're going to have a lot of problems, and I'm against it.
The last person who signed up was Brian Bodge.
Brian Bodge, 3225 Pine Street. If indeed you do decide to enact limitations for Tier 2 and Tier 3 facilities, I think that one of each is probably too restrictive. You've got to come up with something that's probably somewhere in the middle to accommodate the people that are out there for this industry. I just don't think that, I don't think one is enough. Thanks.
Would anybody else care to comment on amendment number 2, proposed amendment number 2? Seeing none, then do I hear a motion to close the public hearing?
So moved.
Second?
Commissioner Zielinski,
Yes.
Commissioner Beck,
Yes.
Commissioner Jordison,
Yes.
Commissioner Tisdale,
Yes.
Commissioner Holland,
Yes.
Chair Stewart.
So, discussion or question,
Yeah,
Commissioner
you don't
Holland?
mind. Thanks. Alan, was there a recommendation from the staff on what that limitation might be in the terms of number of facilities, square footage. That's my first question. Then secondly, I know there's no Tier 1 facilities currently in the city. Do you recall if there's been any applications for Tier 1s, 2s, or 3s through the state?
I've only seen one Tier 1 application that just came in yesterday. And so we haven't had any Tier 2s or 3s because they wouldn't be allowed under the interim regulation.
Thank you.
And I believe the staff recommendation on page 3 is 1 Tier 2 and 1 Tier 3.
Sorry.
Correct.
Comments? Commissioner Zelinski?
Yes, I'd just like to say that I fully support the notion of taking a cautious approach because I witnessed what happened in Snohomish County when they did not take a cautious approach, and it creates a lot of pain and anguish for a lot of people. So I think this is the way to do it, is to limit the numbers. So I will fully support the staff's recommendation on this one.
Other commissioner comments, questions?
One additional question. So there would not be a, I'm sorry, there wouldn't be a limit on Tier 1s then, is that correct?
That's correct. That would not change the current regulation for Tier 1s, for which there is no limit on the number.
Commissioner Jordison?
Yeah, I don't feel that, I think one of each is way too restrictive. I could see maybe 5 of each. I think even if you had 5 Tier 3 facilities at 30,000 square feet apiece, that would be, what, 150,000 square feet? And that, it seems to me very restrictive, and it's not allowing for free enterprise and a free market. I think you need to have competition for businesses to stay, competitive. And if there was 5, 150,000 square feet, that's like a tiny fraction of what Boeing just completed. What did they build? A million square feet, something like that. So I would probably support it, even if we only allowed 1, because, like, in my mind, it's a gain, it's a net gain, but it's awfully restrictive, and it almost sets up a little bit of a kind of almost a protectionist thing where, if one thing doesn't work out, I mean, one could be going out of business, and another one, if another one can't open up right away, then, there could be supply problems. So those are just some thoughts that I have. I think that overly kind of keeping our hands around the throat of this thing was maybe a little bit, just one facility is a little bit too restrictive.
Commissioner Beck?
I tend to agree on this one. What I'm struggling with is size of facility, and I'm sorry I misplaced your name, but this gentleman's advice in that we don't want to have a gold rush up here by just opening it completely up. I do see, just 1 of each tier as being very restrictive. So I do think that we should make some recommendations on some limits, but 1 that's pretty few. The other question I have is size of facility. And this is where I don't have a lot of information. I'm curious as to what the Tier 2 and Tier 3, what the largest facilities that have been permitted in the state. Yes, if you have that information, I'm just kind of trying to get an idea of what the size and scale of these facilities are in terms of the...
Actually, let's hear from staff first.
Alan Giffen, staff, under the maximum allowed under the state law, Tier 2 would have 10,000 square feet of canopy, and a Tier 3 up to 30,000 square feet. And Mr. Dottie may know more about this with the Liquor Control Board's easing in of the regulations. I believe that they limited even the Tier 2s and 3s to something less than that.
They scaled everybody back by a third.
Okay.
So from the 30,000, you're down to 21,000. about what building size did it end up in, right?
Right, that's basically my question.
The largest one I know about.
Would you mind approaching, just so we can get it on the microphone? Thank you.
Again, Philip Doughty, representing Mojo Rising. I think the biggest building I know of that a Tier 3 is in, the entire building that they're in, and really they're only in a portion of the building. It's a large building that has multiple businesses in it. It's probably a 200,000 square foot building in Lacey. I believe they have a 50,000 square foot portion. And they've got neighbors on either side of them, and it works out fine. It's a currently existing building, doesn't really look any different from anything else. But that's the biggest one I know about at this point.
I remember at one of our earlier workshops, we did see a slideshow that showed some of the structures that would be these Tier 1, 2s, and 3s to sort of give us an idea. And I think there was also some mention that they could be multi-story even, so a stacked up, and so it's more the floor area ratio that if we wanted to have a limit at some point. But it sounds as though evidently the Liquor Control Board has the square footage limits already in place. So, Commissioner Holland.
Correct me if I'm wrong, Alan, it really doesn't matter what the size of the building is, it's really just the canopy, is that correct? You can have offices and other things, so if you wanted to do a 21,000 square foot of canopy, which is currently allowed under state law, you can still have a 50,000 square foot building where you're doing all your office and processing and other things like that, is that correct?
That's correct.
Thank you.
Yes.
So I would speak in favor of the staff recommendation of 1. I think it was said well by Michael and from the representative from the industry. My reason for going against the recommendation on 1 was I think this is something that we need to look at, and how do you look at it and really know what the impacts, good or bad, are if you don't go through that exercise. And at the same time, I think what was the experience at the county with the rush, they're going to go someplace, and my first vote on the first recommendation, I certainly don't want to open it up to, I like I said, I had a conversation with Laney and the City Economic Development Director, Laney, and around that conversation, it was, how do we know if we don't try? That was my take on it. That isn't what she told me. And so that's why I would support, let's hold it in close, and I'm all for economic development. That's what I eat and breathe, and blood and all that stuff. But there's communities around the United States and the world that wish they wouldn't have let certain industries. I'm not just saying marijuana. So I would support the recommendation of the council, or excuse me, of the staff.
Comments, or are we ready for a motion?
I would move the staff recommendation on this amendment to support the limit of 1 Tier 2 and 1 Tier 3.
I'll second that.
Commissioner Zielinski?
Yes.
Commissioner Beck?
No.
Commissioner Jordison?
No.
Commissioner Tisdall?
Yes.
Commissioner Holland?
Yes.
Commissioner Stewart?
Yes. All right, that motion then passed. So that will pass 4-2. So that would limit proposed potential Tier 2 and Tier 3 facilities to 1 each to be considered. So now we move to amendment number 3. Staff, would you like to introduce that one, please?
Yes, Alan Giffen, planning staff. This one resulted directly from testimony of Mr. Doughty at one of the earlier workshops. He has a client who has apparently an agreement with the building owner to have a production and processing facility, in a building that is split by two different zones. The M2 zoning is an industrial zone that currently, under the interim regulations, does allow for production and processing. Of course, under the current regulations, that limited to Tier 1, but the MS is the Maritime Services Zone. It is a zone that does not allow for the production and processing. The building that his client is interested in is split by that zoning. We only have one area of Maritime Services zoning in the city. That is the area where the Gerald-Wynn door plant used to be located. It's on the north end of the waterfront, north of the mud flats area there, right at the very tip of that property that's being leased by Cemex. It's a asphalt batch plant that is out on the far end of that property. And so that is the only location where we have the MS zoning. The staff recommendation, again, is based on taking a very conservative approach and recommending that we not allow the production or processing in the Maritime Services Zone.
Okay, thank you. And now we will take public comments on proposed amendment number 3, starting with Philip Dowdy.
Can I wait for the other commissioner to return? He's coming right back. Hi again, Philip Dowdy, for the record, representing Mojo Rising. The only reason we had done this ask in the earlier workshops was because this is a unique piece of property that's split by 2 zones. It goes right down the middle of the building. And it's one of the, it's not the big I can never quite say that name. Is it Gerald-Wynn?
Gerald-Wynn.
Gerald-Wynn. It's not the big, huge 400,000 square foot building that probably most people are familiar with as that company's former property. There's a building just to the south of it that used to be part of that as well. That's, I think, about a 35 or 40,000 square foot building. And it's just because of old survey lines, it's split in the middle. Part of it is M2, part of it is MS. There's certainly industrial type uses going on out in that sort of area. Like he said, there's some asphalt work that goes on out there. I can't, at the end of the day, tell you what's right and not right for a maritime services zone relative to cannabis production. But what I can say is you now have a limit of 1 as your recommendation for Tier 3. So, and this building is kind of unique. This landlord does not have aerospace companies beating him up to rent it or anything, or biotech or anything like that. He really wants to rent to these guys. He strongly believes in the issue. And in addition, he'd like a client renting his property, which he has not had for several years just because of the economic downturn. I don't know how else to make the case, except I would ask that if you do want to allow it in the MS portion of the zone, that the 1,000-foot buffer from residential areas, that you incorporate the same language that's in the current regulations for retail that allows the planning director to use a common sense approach on those things, because this project has a rail line in between it and a residential area, an active rail line, an active street, Marine View, west. It has a 100-foot cliff to get to the neighborhood, and in between all of that is a salt marsh. So I think the chances of anybody coming down from the neighborhood are extremely limited. Thank you.
Next would be Arnold Brasseur. Would you like to speak on this amendment number 3? Okay. Next is Bob McGowan. Okay, he passes. Sonia Bodge. Okay, she also has no comment. And next is Dennis Kavanaugh, who has left, so no comment. And the last person who signed up is Brian Bodge. No comment. Okay, no comment on that person, from that person. So anybody in the audience who would like to speak to proposed amendment number 3? Seeing none, do I hear a motion to close the public hearing on this item?
So moved.
Second.
Commissioner Zelinski,
Yes.
Commissioner Beck,
Yes.
Commissioner Jordison,
Yes.
Commissioner Tisdale,
Yes.
Commissioner Holland, Chair Stewart.
Yes. All right. Turning back to the commission now. Regarding proposed amendment number 3, anybody have questions? Yes, Commissioner Holland.
Question for staff. This particular property, is the zoning split through a parcel line? The building's just built over a parcel line, or is it actually a parcel that truly has a split zone?
It's the latter. It was an area that had a little bit of industrial zoning toward West Marine View Drive. And years ago, for whatever reasons that go way back before my 29 years with the city, the rest of that property was unzoned. And in the mid-90s, we did establish zoning for that, the rest of that area, and applied the Maritime Services zoning to it. So it was just one of those unusual situations where you have a zoning boundary that splits a property. It's not following any parcel boundaries.
Has there been any discussion or consideration in our comp plan update to marry a parcel line with the zoning designation where this may not be an issue in the future?
No, we haven't really had that level of discussion on some of these map issues that are with property like this. It's a very large property, and it's a fairly good-sized area that's zoned M2. It's an even bigger portion of the property that's zoned MS. When it was just, if it were something where it was just a very minor adjustment, we have been making those kinds of corrections, but that's a good question, but we haven't proposed that in the comp plan update.
Thank you.
I guess a question that brings up for me is, how much of the property is within shoreline jurisdiction?
I don't believe the building in question is in shoreline jurisdiction. There is, it is a fairly large property, and even the batch plant is outside of the 200-foot shoreline jurisdiction. The only thing that's in shoreline jurisdiction on the batch plant is really the gravel unloading, barge unloading facility. And so we kept the area nearest the water available for water-dependent uses. And so this building is outside of shoreline jurisdiction by a fairly good distance.
Okay, thank you. Other comments, questions?
Ellen, did the port have any communication with you? That's port property?
The port does have some property that is zoned maritime services as well, adjacent to the Jeld-Wen property, but we have not had any communication from the port.
Thank you.
Other comments? Commissioner Zelinski?
I have a question, actually. Can you tell us what the intent and purpose of the MS zone is?
Maritime Service Zone is intended to be a working waterfront kind of zoning to allow for water-dependent type of uses along the shoreline. Again, this is the only area that has that zoning, and it was applied in the mid-90s at times when we were expecting some more industrial development, redevelopment of that. Well, I take that back. At that time, Jeld-Wen was actually operating as a door manufacturer, so I better not trust my memory. It's been 20 long years since that action. So,
Other comments, questions? Commissioner Holland?
Just one additional question for staff. If the commission elected to approve this particular amendment to allow in the MS zone, would it only, is the language such that it would really only affect this building? Would that be a fair statement?
that's a fair statement. This property, the two buildings are split by the zoning boundary.
Okay, thank you.
If there are no more questions, anybody ready to make a motion regarding proposed amendment number 3?
Back to his question, so that MS zone is bigger than just the Jeld-Wen property?
Right, it really applies to the Geldwin property and the Port of Everett Baywood property.
And so it would be that if if the decision was to not take the recommendation of the staff, would it then be that whole chunk of property, the Porch property and the Geldwin property?
It would be any property that has split zoning. And in this case, the Baywood property has no buildings on it. Not to say that one couldn't be built there. It's unlikely the Port would build a building for this purpose or allow a tenant to, is my understanding. So it probably would only affect, again, this property, which has 2 buildings that are split by the zoning boundary.
That MS doesn't go down the rest of the way, the waterway? DMS zoning?
It may, but it's all tidelands. I don't remember exactly the southerly extent of that.
So it doesn't come back out all the way down to the Weyerhaeuser property?
It does not include the, for example, the boat launch property north of the Port's Waterfront Place development. That's not included.
Any motion?
I'll motion to add the MS zone as a zone which, add it to the list of zones in which production processing facilities are permitted.
Before we discuss, we need a second. Does anybody second that motion?
I'll second.
Okay. Commissioner Zelinski?
I'd just like a clarification. It's under a limited condition, only when that condition up there applies, when you have a property split by the, so it's not a general, at least as written there, and I'm just wanting to clarify if that's what your motion is.
I could take that as a friendly amendment, sure.
Okay. Any further discussion?
Yeah, I just want to be clear on the record. So, so the motion that's on the floor for us to vote is to allow a producer processor facility when it involves a split zone between the MS and M2 zone, not specifically in the MS zone. Is that correct? Is that the correct motion?
You know, I think that I understand you're attempting to narrow it down, but I mean, this is kind of a unique situation where we're basically, I'm under the impression that we were, so this is only in this one circumstance where you have a split, a piece of a parcel with a split zoning. Is that the case here? Was that the intent?
One parcel with 2 buildings that have 2 different zones that apply to them because the zoning boundary runs through each building.
Because as I read this, you know, the adding the MS Maritime Services, okay. It says in item number 3, it says nothing about a split. Or
Can I ask for one clarification from the previous motion that we approved? So the motion was industrial lands. This is considered an industrial land, correct? Or to approve through special use permit?
Yeah, this would be eligible for the tier 1, or excuse me, tier 2 and 3.
Because MS by definition is considered an industrial land? Do you understand?
No, under the interim regulations, we didn't specifically call out the MS zone as a zone in which production and processing were allowed.
So if I were to restate my motion, is that, so the motion as stated up there is different from item number 3?
I may have paraphrased it on the PowerPoint slide just to fit everything on there.
But, you know, I think because I'm gonna go ahead and stick with it as amended by Commissioner Zelinski, because that piece of property, that building has been sitting vacant for as long as I can. I mean, there's a very, very depressed area of the city, and although it shouldn't be, it's a nice area, but we've had an empty kind of locked gates and an empty building for quite a while now, and it sounds like the property owner could use an infusion of cash, and you know, in this one particular situation, even if it's not a blanket zoning change for for all the MS zones throughout the city, I would tailor my motion to suit this particular situation, this unique situation with this unique piece of property.
And so, yeah, I would recommend that you use the language that's in the staff report, which I paraphrased on the slide, so I'll just go ahead and read this so that everybody has the same understanding. It would be adding the MS, Maritime Services Zone, to the list of zones in which production processing facilities are permitted when a property is split by a zoning boundary having both M2 heavy manufacturing and MS, Maritime Services zoning on the property, and the business is located in a building that is partially within the M2 zone.
Okay, so that's the motion.
Okay, we have a motion, and I believe it's been seconded. All right.
Commissioner Zelinski?
Yes.
Commissioner Beck?
Yes.
Commissioner Jordison?
Yes.
Commissioner Tisdale?
No.
Commissioner Holland?
Yes.
Chair Stewart?
Yes. All right, that motion is passed 5-1. Now moving to proposed motion number 4. Staff can introduce that one.
Right, and we touched upon this a little bit earlier when we were talking about the first item. This would be an amendment to eliminate the 1,000-foot separation between production and processing facilities and properties located in residential zones, but would establish public notification review process when proposed within 200 feet of a residential zone. It's one that we've discussed in earlier workshops. Staff's recommendation is not to reduce the separation requirement between production and processing facilities and residential zones, keeping it at the 1,000-foot current separation requirement.
Okay. So public comments on this particular item, and then we'll have commission questions. So Philip Dowdy, looks like he's no longer here. Arnold Brasseur.
Arnold Brasseur, I gave my address previously. I'd recommend the adoption of the staff agreement on this and keep the separation. Thank you.
Next, Bob McCowan.
I agree with the staff recommendation to keep a 1,000-foot buffer. The fact that the government is condoning the sale of marijuana is sending a mixed message to our children. And the closer the proximity, the more apt there is for usage to go up. The more readily pot is available, the higher the consumption goes up. And I think just as good stewards, we have to protect our children, and a 1,000-foot setback is the minimum we can do to do that. Thank you.
Next is Sonia Bodge. Okay, Ms. Bodge passes. Dennis Kavanaugh has left. Brian Bodge.
Brian Bodge, address previously stated. I support the elimination of 1,000-foot separation between this particular item here. One of the reasons is also in some of the proposed legislation that's coming up in House Bill 2136, if there could be a possibility that the city could forego potential tax revenue for those municipalities that prohibit state licensed producers, processors, and retailers. So that's just one thing that you might want to consider, that if you do enact prohibitions that later down the road, some of the tax sharing that the state is proposing could be withheld. Thank you.
Okay, is anybody else wanting to comment from the public on this proposed amendment number 4? You already commented. If you could keep it to 1 minute.
Less than that.
Okay. Mr. Brasseur.
Arnold Brasseur, in regard to tax revenues, my own personal opinion, and I would ask you to disregard the financial tax revenue aspect of this and protect our children and keep the 1,000-foot buffer. Thank you.
Okay. Do I hear a motion to close the public hearing on proposed amendment number 4?
So moved.
Second?
Commissioner Zelinski,
Yes.
Commissioner Beck,
Yes.
Commissioner Jordison,
Yes.
Commissioner Tisdall,
Yes.
Commissioner Holland,
Yes.
Chair Stewart.